Delhi Lieutenant Governor Vinai Saxena has approved the prosecution of Arundhati Roy and Dr. Sheikh Shaukat Hussain, a former professor from Central University of Kashmir. Now take a look at this. The FIR was based on a complaint by Sushil Pandit and dates back 14 years. Aditi Roy and Arundhati Roy, beg your pardon, and Hussain allegedly gave provocative speeches at a conference titled Azadi, the Only Way, which was held in the national capital. Now, other participants included Kashmiri separatists Syed Ali Shah Gilani, a former Delhi University lecturer Sar Gilani, and activist Varavara Rao. All three of these participants have since passed away. The charges stem from speeches delivered at the conference that was titled Azadi, the Only Way. The conference was held on the 21st of October in 2010 at the LTG auditorium in the national capital on the Copernicus Marg here. Now, the conference took place amidst a period of intense unrest in Kashmir following the death of a 17-year-old boy named Tufail Ahmed Mattu, struck by a tear gas canister. Now, the FIR in the case was filed after complaint by Hindu activist Sushil Pandit in 2010. He alleged that several of the speeches, including one by Arundhati Roy, had quote-unquote jeopardized public peace and security, further asserting that speakers promoted separation of Kashmir from India. Now, Section 13 of UAPA, that's punishment for unlawful activities. Section 124A for sedition. Section 153A, that's promoting enmity between different groups. Section 153B, which means imputations prejudicial to national integration. And Section 504, intentional insult to provoke breach of peace. Another charge that was listed out was Section 505, that's statements conducing to public mischief of the Indian Penal Code. These are the charges against Arundhati Roy. 14 years later, the Delhi Lieutenant Governor has, given a green light for the prosecution of it. News 9's legal editor, Ashok Bagaria, joins us live on the broadcast here. Ashok, a very good morning to you. I mean, mind-boggling news. At least that's how the internet is reacting to this at this point in time. People are saying 14 years far too long in this case.
Well, yes, it's been it's been a long time, but you have to keep in mind the fact that the FIR was lodged in the very same year in which that allegedly provocative speech was made by Arundhati Roy, and it was in an auditorium in Delhi. Now, the more controversial bit here is today that some 8 months back, Arundhati Roy was accused, and Shaukat Hussain, professor at the Kashmir University, they were charged for delivering hate speech. So the Delhi police had approached the Lieutenant Governor seeking permission to seeking sanction to prosecute Arundhati Roy and Shaukat Hussain under the provisions of the Indian Penal Code. But however, there was this original FIR which contained provisions of the Indian Penal Code as well as the UAPA. So while 8 months back, the LG gave sanction to prosecute Arundhati Roy and Shaukat Hussain under the provisions of Indian Penal Code, he did not give sanction for the UAPA offences. Now, there are stories or reports, media reports, which are emerging, which are saying that this sanction has come 8 months late because the government of India or the Delhi government wants to bypass the limitation period or the Limitation Act. Now, please try to understand that as far as Limitation Act is concerned, the Limitation Act basically bars or rather sets a time period for filing of FIR. So it says that for offences which are of less grievous nature, maybe 6 months, which are punishable with 6 months, 1 year, or 3 years, the bar is up to 3 years. But for more serious offences like rape, murder, kidnapping, where the quantum of sentence is more than 7 years, there is no limitation. Now, under the UAPA Act for which they are being charged, Arundhati Roy and Shaukat Hussain, the quantum of punishment is 10 years to life term in jail. So here, the Limitation Act does not apply, and therefore, there is no bar. The problem here is that there are two things: filing of the FIR and taking cognizance by the court. Now, what happens if there is no sanction by the central government to prosecute somebody under the UAPA? They are set free. And this is what we witnessed recently in the case of GN Sai Baba, who is an accused in the Bhima Koregaon case. The Bombay High Court held that there was no sanction to prosecute Sai Baba under the UAPA, and hence the Bombay High Court came to a conclusion that he cannot be prosecuted under the UAPA. So, as far as Arundhati Roy and Shaukat Hussain are concerned, there is serious trouble for them in the days to come.
All right. Legal, if we quickly talk about the legal remedies over here as well, because, I mean, apart from the political vendetta that everybody is going on at each other, we just saw, Mahua Moitra saying that if this is a way for the BJP to tell the world that they are back, well, they're not. But apart from the politics, legal remedies for Arundhati Roy and Shaukat Hussain at the moment, Ashok?
Well, actually, the legal remedies for them will be to go to the court, challenge the sanction. Number one, they can challenge the sanction saying that it's come almost 14 years after an FIR in this matter was lodged. So there was an unreasonable delay on the part of the central government in according sanction. The second thing is that as far as hate speeches are concerned, the cognizance was taken at an earlier date and sanction has been accorded. So in that offenses, they can continue to agitate their rights to free speech, saying that what is free speech if you cannot make provocative speech. But in this particular case, the allegation against Arundhati Roy and Shaukat Hussain is that they made a case out for separation of Kashmir from the Union of India. Now, this certainly falls into a more serious category of offense when it comes to free speech. What will have to be determined is that if you make, if you voice such a sentiment or an opinion, is it covered or protected under Article 19(1) of the Constitution of India, or rather Article 21, which gives you the freedom of expression, speech and expression. So these are the things that will have to be seen, how the court interprets them, and it's still a long way to go. But
Right.
For Arundhati Roy and Shaukat Hussain, there could be trouble because once the court takes cognizance under the UAPA, their passports can be impounded or cancelled.
Well, more than just legal trouble for these two at the moment.